Mr. Speaker, I rise today to highlight 10 ways in which the state of California is currently under federal investigation. In particular, the Newsom administration under federal investigation. Now, the New York Times recently ran a story on this topic, headlined, "Trump Takes Aim at California." The question was, why is the administration targeting California? They called it a multi-pronged assault on California that has begun in earnest. But that's actually the wrong question, to ask why the administration is targeting California. The appropriate question is, why is California so flagrantly violating federal law in so many different ways? In the article, the junior senator in our state, Adam Schiff, is quoted as saying that the president has a, quote, partisan vendetta against California. Senator Schiff says that he is continuing to weaponize the federal government against California. Of course, that's not it at all. Protecting the civil rights of Californians is not weaponizing the federal government. It's what the federal government is supposed to do, what it's required to do under established law. You see, what Senator Schiff and others are so upset about is that they're used to one-party rule in California being absolutely unchecked. They are used to radicalism having absolutely no counterweight. They're used to our governor, Gavin Newsom, whose only motivation is his own political self-promotion, having a supermajority legislator and other statewide elected officials that simply go along with whatever he says or does, regardless of how much damage it does to our state and regardless of how clearly it violates federal law. So when the Times asked my opinion for this article, what I said was that extreme policies and unchecked one-party rule have lowered the quality of life across our state. All Californians will benefit from greater accountability. We need balance and common sense. So I wanted to discuss today the 10 ways in which federal investigations are restoring that sense of balance and common sense and assuring compliance with the law. Number one is on the issue of men in women's sports, where the state has continued to be defiant. Recently, the U.S. Department of Education's Office for Civil Rights announced a directed investigation into the California Interscholastic Federation because of its refusal to follow anti-discrimination laws related to girls and women's sports. This includes the possibility of allowing male athletes to compete in women's sports and use women's intimate facilities. Governor Newsom has received as well a letter from U.S. Education Secretary Linda McMahon warning the governor that California could lose federal funds if the state continues to allowing transgender athletes to play in girls and women's sports. As Secretary of Education, Secretary McMahon wrote, "I am officially asking you to inform the department whether you will remind schools in California to comply with federal law by protecting sex-segregated spaces and activities." She also wrote, "Allowing participation in sex-separated activities based on gender identity places schools at risk of Title IX violations and loss of federal funding." She says, "As governor, you have a duty to inform California school districts of this risk." Interestingly enough, Governor Newsom actually recently stated that he believes it's unfair what the state is doing, allowing for men to compete in women's sports, and yet he has taken absolutely no action to stop this unlawful practice. The second ongoing investigation relates to California's policy of forcing school districts and schools to keep secrets from parents about their own students, about their own children. The U.S. Department of Education's Student Privacy Policy Office has launched an investigation into the California Department of Education for alleged violations of the Family Educational Rights Privacy Act, known as FERPA, which gives parents the right to access their children's educational data. The California Department of Education, it is alleged, has abdicated the responsibilities FERPA imposes because of a new California state law that prohibits school personnel from disclosing a child's gender identity to that child's parents. So what happened in California is you have a number of school districts that have said that we're simply going to hide this information from parents. We're not going to tell parents if their child changes their name or changes their pronouns or anything like that. You then had some other districts that said, well, this is not right. We actually want to make sure that we're being open and transparent with parents. So they passed their own policies saying, no, our policy is that we believe that parents have a right to know this. What the state then did is started suing these districts, trying to get legal judgments against them, saying you are required under law to lie to parents about their children. Fortunately, those lawsuits are being rejected, but the state legislature then followed up with a statewide law saying that it is now the policy of the state that you are not allowed to communicate this information with parents, that school districts are not allowed to have any policy that allows them to communicate this information with parents. So think about the absurdity of this. In California, you have teachers are forced to use one name and one set of pronouns with a student in class. Then their parents come in for a conference and they're supposed to switch names and switch pronouns and doctor their assignments and the names written on them, which has actually been done in documented cases in California. Thankfully, this federal law is on the books, protecting the privacy right of students and the right of parents to know this information, and the Department of Education has launched a federal investigation accordingly. The third ongoing investigation relates to the issue of racial discrimination in California higher education. The Department of Justice, under Attorney General Bondi, is investigating several California universities to assess compliance with the 2023 U.S. Supreme Court ruling that ended affirmative action in college admissions. Now, this is notable because not only is this now the supreme law of the land per the recent Supreme Court decision, is that you have to have equal access, but it's also the overwhelmingly expressed will of California voters. Just a few years ago, in 2020, the supermajority legislature tried to repeal an existing state constitutional provision that forbade racial discrimination in college admissions. So they put it directly on the ballot by a supermajority. They passed a measure to put it on the ballot, but the people of California said no. Despite the campaign for this initiative having a massive, I think, 10-to-1 spending advantage, the people of California voted 57% to 43% to say, no, we want to continue to have equality under law be the policy of our state. So this investigation by Attorney General Bondi is not only about assuring compliance with federal law, but is also going to protect the clearly expressed will of the people of California. The fourth investigation relates to the crisis of anti-Semitism at our universities. The Federal Task Force to Combat Anti-Semitism has announced that the Department of Justice has opened a civil pattern of practice investigation into the University of California under Title VII of the Civil Rights Act of 1964. The investigation will assess whether the UC is engaged in a pattern or practice of discrimination based on race, religion, and national origin against its professors, staff, and other employees by allowing an anti-Semitic hostile work environment to exist on its campuses. Attorney General Bondi said, quote, "The Department of Justice will always defend Jewish Americans, protect civil rights, and leverage our resources to eradicate institutional anti-Semitism in our nation's universities." We've seen over the last year and a half or so absolutely abhorrent, outright anti-Semitism at many universities throughout the country, including at California universities, which our Committee on Education and the Workforce did a lot of work to expose through a number of hearings. And while there have been some positive reforms that have occurred on some campuses, there are still many ongoing, very severe problems with these issues being aided and abetted in a lot of cases by university faculty and administrations. So this is an investigation into the full gamut of that activity. And then there's a related set of investigations that are looking at the extent to which students who are here international students are actually working to advance not only anti-Semitic, but pro-Hamas type activity. We saw, related to all of these anti-Semitic incidents on university campuses, illegal activity as well, with illegal encampments that violate the law, violate university policies, violate the civil rights of other students. We saw buildings being taken over, and we have seen connections between these activities and the agenda of Hamas and Hamas-affiliated groups. So recently, the the administration has revoked about 100 student visas at universities across California, including the University of California at Berkeley, which is part of a broader assessment of individuals who are involved in activities deemed contrary to U.S. interests. Now, this is actually a pretty small number, 100 out of 140,000 international students that are in California, but we do know that there are people who are here who are not from this country who have participated in these illegal activities, because as the president's order cites, federal law bars non-citizens from being in the U.S. if they support terrorism. And so any connection with pro-Hamas activity falls under the purview of those statutes. Indeed, the executive order from the White House quotes the president as saying that his intention is to deport Hamas sympathizers and revoke student visas. In a similar vein, UCLA has been sued in federal court in a case alleging that it enabled protesters at an encampment to block Jewish students from accessing certain campus pathways. To the extent that folks who are here on a visa were involved in that sort of illegal pro-terrorist activity, the administration is doing an assessment to take appropriate action. The sixth investigation that is going on against some of the insane and potentially illegal policies in California relates to high-speed rail, which is the biggest public infrastructure failure in United States history. I was at the train station in LA, Union Station, a couple weeks ago, where we were with Transportation Secretary Sean Duffy announcing this investigation specifically into the federal money that has gone into high-speed rail. The review that we launched on that day will help determine whether roughly $4 billion in taxpayer money should remain committed to the proposed project to build high-speed rail in the California Central Valley between Merced and Bakersfield. I have also requested an investigation by the FBI into how exactly it is that California has so far spent some $17 billion on this project, which was approved in 2008, so we're talking over 15 years, and has yet to lay any track. At this point, even the New York Times has said the project isn't going to be completed this century at the current pace. The overall cost has ballooned to over $130 billion. That's more than $100 billion more than it was supposed to be. The whole thing was supposed to be completed by now, per the initial projections, but now at this point, even the first segment from Bakersfield to Merced, a very modest segment, they're saying isn't even going to be completed by 2033. And indeed, just last week, there was a report from the nonpartisan legislative analysts that there's another $9 billion funding gap, and they're continuing to rely on federal funding. So this is an investigation that is ongoing, and I fully expect it will result in those funds being clawed back and hopefully then used on infrastructure projects in California that will actually serve to move people and goods, will create jobs that have positive economic value, and will actually be helpful in improving the quality of life for folks in our state. The seventh ongoing investigation relates to California's cap and trade program. An executive order from the president has directed Attorney General Bondi to identify state and local acts that may be unconstitutional or preempted by federal law. And it singles out California's cap and trade program, which sets limits on greenhouse gas emissions and then has companies buy and sell credits. As the order says, California punishes carbon use by adopting impossible caps on the amount of carbon businesses may use, all but forcing businesses to pay large sums to trade carbon credit to meet California's radical requirements. What is the result of this? Even as we have seen gas prices that have gotten much lower across the entire country, Californians continue to pay astronomical prices when they fill up their cars. Indeed, California is now some $1.60 above the national average. We have the highest gas prices in the country, higher than even Hawaii, and the major cause of that is the state's taxes and regulations and other requirements, foremost among them being this cap and trade program, which adds substantially to the price of each gallon of gas. The eighth ongoing investigation relates to the homelessness crisis in California. California is the national leader in homelessness. It is not even close. We have roughly half the unsheltered homeless in the entire country, despite spending absolutely staggering amounts of money. Indeed, over the course of the last 5 years, we have seen $24 billion spent on homelessness, and homelessness has continued to go up significantly. A recent audit actually found that the state has lost track of the money and can't even tell you where it went or what outcomes it has produced. But now the new United States Attorney for the Central District of California, Bill Kiley, has announced the formation of the Homelessness, Fraud, and Corruption Task Force, which will investigate fraud, waste, abuse, and corruption involving funds allocated towards the eradication of homelessness within the 7-county jurisdiction of the Central District of California. The task force will be comprised of federal prosecutors from the Major Fraud Section, the Public Corruption and Civil Rights Section, and the Civil Division Civil Fraud Section of the U.S. Attorney's Office. And it'll specifically look into what's going on in Los Angeles, where recently a court-ordered audit found that homelessness services provided by the city and county were, quote, disjointed and contained poor quality and integration. And there's a lot of federal money at stake at issue here, by the way. During COVID, the federal government sent $100 million in emergency aid to LA County to address homelessness, and last month, the U.S. Department of Housing and Urban Development awarded more than $200 million to address homelessness in LA. So now there is a federal investigation ongoing, led by the U.S. Attorney's Office, into exactly what has happened to all of this money. The ninth ongoing investigation relates to concealed carry. As part of a broader review of restrictive firearms-related laws in California and other states, the Department of Justice's Civil Rights Division has announced an investigation into the LA County Sheriff's Department to determine whether it is engaging in a pattern or practice of depriving ordinary law-abiding Californians of their Second Amendment rights. The release from the Attorney General's office notes that a recent federal court decision found that the law and facts were clearly in favor of 2 private plaintiffs who challenged the lengthy 18-month delays that the LA County Sheriff's Department had imposed when processing their concealed handgun license applications, and that the Civil Rights Division has reason to believe that those 2 plaintiffs are not the only ones in this county of some 8 million people experiencing long delays that are unduly burdening or effectively denying the Second Amendment rights of the people of Los Angeles. The release from the Attorney General goes on to note the ways in which the Second Amendment rights of Californians have been unduly burdened in countless ways. They call California a particularly egregious offender. In response to recent Supreme Court case law, California enacted new legislation to further restrict the ability of ordinary, law-abiding Californians to keep and bear arms. And many California localities appear to be imposing additional burdens beyond those required by California state law, including by subjecting ordinary, law-abiding Californians to expensive fees and lengthy wait times associated with applications for concealed handgun licenses. So now there will be some counterweight to these measures which are restricting the rights of Californians. In fact, there was even a recent proposal in the legislature that went to the very core of the Second Amendment that would have said that you're no longer allowed to defend yourself against an intruder who breaks into your own home. Luckily, that bill was defeated, but it just shows you how far California has gone from what is protected by the Constitution. And finally, of course, there is ongoing federal action, and this being the 10th federal action related to California when it comes to sanctuary jurisdictions. The Attorney General and the Secretary of Homeland Security, pursuant to an executive order from the President, are looking to the maximum extent possible under federal law. They're evaluating and undertaking any lawful actions to ensure that so-called sanctuary jurisdictions, which seek to interfere with the lawful exercise of federal law enforcement operations, do not receive access to federal funds. Further, the Attorney General and the Secretary of Homeland Security, per the terms of the order, are evaluating and undertaking any other lawful actions, criminal or civil, that they deem warranted based on any such jurisdictions' practices that interfere with the enforcement of federal law. When it comes to sanctuary policies, California has been the very worst offender in the country. The state has a sanctuary state policy that was passed in 2017 and is responsible for many, many tragedies that have been documented throughout our state. And then you even have jurisdictions like Los Angeles and San Diego and San Francisco that were already sanctuary jurisdictions on top of being within a sanctuary state, but are now even going further, one of them even passing what they're calling a super sanctuary jurisdiction ordinance. We have, those of us who represent districts in California that are not sanctuary jurisdictions have also asked the administration to be sure to recognize those counties and jurisdictions that are in good faith trying to comply with federal law, very much unlike jurisdictions like Los Angeles, San Diego, and San Francisco. So these are 10 ways in which we see finally something of a check on the runaway lawlessness of the Newsom administration and a number of jurisdictions in California. And in Congress, we are very much a partner in those efforts. Indeed, I'm working on a number of measures here in Congress, in the House of Representatives, that are seeking to push back on the radical, harmful policies of the Newsom administration. For example, we recently introduced legislation to overturn Newsom's ban on gas-powered vehicles. I've introduced legislation called the No Medi-Cal for Illegal Immigrants Act, which will seek to preserve Medi-Cal benefits for American citizens at a time when the policy of expanding those benefits to everyone in the state illegally is literally bankrupting the system. And in addition to Secretary Duffy's investigation into high-speed rail's staggering failures, I've introduced legislation to assure that the high-speed rail project will be ineligible for any federal funding going forward. California has a long way to go towards restoring sanity, but these actions are very important steps, and I look forward to following these investigations as they protect the civil rights of Californians and protect our citizens against truly radical and failed policies.